Good morning, Ms. Romero. Can you hear me?
I can, Mr. Ginsburg and Mr. Buttermore. Can you hear me?
I hear you. This is King.
Okay, great.
Morning, everybody.
How are you all doing this morning?
Very well, thank you. It's good to see everybody.
Yes, and I have my photo because my photo is looking better than I am today. So you can hear me, but that's a still photo. We are almost ready to go. Judge is walking out to the bench, so I will, I think we'll be ready to go in just a sec. Have you guys had a lot of Zoom conferences?
I've had a few, mostly mediations, a couple of depositions.
How have the depositions gone?
So I think it's a bit of a challenge, particularly when it comes to document cases and scrolling through the documents on what are typically, small laptop screens. It's very difficult for the witnesses.
Yes.
Fortunately for me, it's been the other side that's had the technical difficulties, and they also have experienced things with feedback and
Right.
and internet connections going awry. But
Yes, yeah. But it is the safest option, and it allows us to move forward. And that's our biggest concern, is that all of our, especially our civil cases, because once jury trials start again, it'll be the emphasis will rightly be on criminal trials. And so we're trying our best to keep civil cases going as safely and efficiently as we can. So it's I guess it's the least of all evils.
yes, I understand that.
We had requested a reporter. Is a reporter present?
Mr. Buttermore, when did you request the reporter?
Yesterday by email.
Let me see. Did you request her by the deadline?
I don't know. My paralegal did that. I'm sorry.
Okay.
No,
if
we
you
had
didn't.
a deadline. I'm sure she observed it, or I feel certain.
Okay. Let me check with our court reporter. Okay.
Thank you.
I'm going to put you all on mute. Hold on. By the deadline? Okay.
No, we had a deadline. I'm sure she. Hello. This is he. Yes. don't know when she reached out to you, but I saw an email from her. Are you available? Her name is Jennifer Green, Greene. I have a credit card out for you. Is that okay? Thanks for doing that. Thank you. The reporter just called me and she said she needs about 3 minutes. When I call back.
Everyone, Candace did get in touch with Mr. Buttermore's office, so we're giving her a minute to set up her machine.
Thank you.
Sure.
say something real quick and I'll be all set. Good morning, everyone. I'm Judge Schwall'S court reporter. All that I ask is that everyone speaks one at a time. If my hands go up, that means several people are talking and I can't take it down. So that's all I'll ask from you. And if you need anything from me, you can always email me. Thank you so much.
Thank you.
Good morning.
Good morning, Your Honor.
Morning, Judge.
Basically, we've got a Motel 6 that 3 families owned, and there was a debt of Jitendra Patel that apparently was agreed to be settled by Jitendra Patel transferring his family shares in Shanta, which owns the Motel 6, for $130,000. And the plaintiffs contend that money was paid. Is that correct?
Different case, Judge.
But $130,000 was paid in this case?
No, what we are here for, and good morning, Steve Ginsburg on behalf of the defendant, Atlantic Casualty Insurance Company. The
All right,
plaintiff,
wrong case. I'm sorry. I thought we were talking about a Motel 6. All right, I get it. Okay, all right. Basically, Atlanta Cross Ties, ACT, had an insurance policy with Atlantic Casualty Insurance Company. And you represent the insurance company, Mr. Ginsburg?
yes, Judge.
And Mr. Buttermore, you represent the plaintiffs?
Yes, they are 3 adjacent property owners, homeowners who hired Atlanta Cross Ties, the Stones, the Andersons, and Ms. Brown. And they have made a claim against the policy that Atlantic had issued to Atlanta Cross Ties, and eventually obtained a judgment against Atlanta Cross Ties, and are here in this case standing in the shoes of Atlanta Cross Ties suing Atlantic Casualty.
So the defendant says that ACT was not classified for landscaping operations under the policy, and the loss occurred outside the policy period because the work was ongoing after the policy was canceled. So basically, the defendant insurance company claims the policy is canceled, and even if the policy was in effect, this wouldn't be a covered issue under the policy. Is that correct?
That's correct, Judge. In fact, there are 6 different coverage exclusions under the policy, each of which would independently apply even had the policy not been canceled. I might point out that the only plaintiff who ever made an insurance claim was plaintiff Lindsey Brown. None of the other plaintiffs made a claim, and paragraph 44 of the first amended complaint admits that. So as a threshold matter, the other plaintiffs lack standing to bring their claims here. But the fact of the matter is that there's not a single section of the insurance policy that is alleged to have been breached, and the plaintiffs can't make such an allegation. So that is the problem. There are the fact that the policy was canceled obviously speaks for itself. It wasn't in force and effect at the time, but even if it was, there is a problem because the policy only covers occurrences or accidents are the definition of an occurrence. And there was no accident here. There was a breach of contract by ACT. There was faulty workmanship by ACT. There was a violation of their warranties and obligations to the plaintiffs by ACT, but none of those constitute accidents. So the absence of any accident there can't be any property damage. And so you've got 5 different exclusions. You've got the contract specifically provides that a breach of contract is not covered. That's what this is. The contract specifically provides that there must be an accident on the property, and there was no accident. This was intentional acts by ACT. The policy specifically excludes any faulty workmanship or having to repair or replace incorrectly done workmanship. So leaving piles of dirt, while it may damage physically the property, it's not property damage as the policy defines, which is damage to the property caused by an accident. So each of those separately exclude any coverage. The plaintiffs have not cited any authority. They don't dispute the cases in our motion for the judgment of the pleadings, which support each of those 5 different coverage exclusions. They don't make any effort to address those cases. And they provide no case law of their own that says these exclusions are vague or ambiguous or not clearly worded. So it's a matter of contract construction. And under the policy, there simply is no coverage.
May I respond, Judge?
Certainly.
The plaintiff's property was damaged during the work. Whether it was an accident or not is unknown because of 2 factors. Mr. Horn, who was the sole owner of Atlanta Cross Ties, Inc., is deceased. Secondly, the language in the letter denying coverage, I will admit that Ms. Brown is the one who filed the claim, and she will testify she filed it on behalf of her neighbors. They all had certificates of insurance showing that Atlantic Casualty had insured Atlanta Cross Ties, but there are inconsistencies that are very, very crucial to this case. If you look carefully at the denial of coverage letter from a man named Farrelly, Mr. Farrelly says, as was just indicated, he says, 1, this property is not insured for landscaping. Then he says the policy expired on August the 12th, 2016. Well, he can take that position if he wants to. However, Exhibit B to the complaint, which is a copy of Atlantic Casualty's commercial general liability coverage part declarations, says the following: business description, landscaping, all caps. Then it goes on to say premium classification, lawn care. So we don't know what Mr. Farrelly is talking about in his denial of coverage letter when he says there is no coverage for landscaping. Sorry. Secondly, his statement about whether the work was continuing after the policy expired is a red herring. Mr. Stone, one of the plaintiffs, Mr. Stone has an affidavit, it's Exhibit H2 attached to the first amended complaint. And his affidavit shows color photos, date stamped in July, showing the property damage, large piles of dirt that were piled on the front yards of all 3 of the houses, along with the debris from the removal of all of those cross ties, which were left there for a long period of time. And as a result of that, the property damage claim had already come alive before any failure to pay. We don't know whether there has been no discovery allowed by the defendant Atlantic. They have fought discovery through 4 courts, Your Honor. We've been in Gwinnett, we've been in Cobb, we've been in your court for 1 day. It was removed to the Northern District and it was remanded back to your court on March 9. And now we have some discovery that has been served on Atlantic, and they're filed a protective order saying there shouldn't be any discovery. There are too many questions about how Atlantic came to send a letter to one of the plaintiffs and say there's no coverage for landscaping, which is totally inconsistent with the part declarations, or the deck page, as some people like to call it.
How much are your losses, Mr. Baltimore?
Yes,
How much are your clients' losses?
they sued for $80,000, which is the amount of the judgment that they obtained against Atlanta Cross Ties. The bottom line, Judge, is they paid Atlanta Cross Ties $80,000, and then they had to, and then after he abandoned the project, they had to pay somebody else a similar amount.
It does sound like to me it's a breach of contract case where the workmanship was faulty and their damage is from a breach of contract. But Mr. Ginsburg, you say there's no coverage for a breach of contract claim, and you say that the policy lapsed. When did when is the last time ACT was over there at the properties, and when did the policy lapse?
According to the First Amendment complaint, plaintiffs pled that on December 20th, 2016, ACT abandoned the work. The policy had lapsed and terminated as of August 12th, 2016.
Does the policy say, what is it, a claims-based policy? Is it clearly, when did the work start, Mr. Buttermore, on the properties? What time period was the work going on? I understand they say it was abandoned on the 20th of December.
Right. I will have to double check, but I believe Mr. Horn and his company had been on the scene for about 2 months. They had had enough time to remove the cross ties that spread across the common rear boundary lines of all three parties and bring that forward. And then all the dirt that fell out, they put that in the front yards, and that debris was in there. And, we believe that there is property damage coverage in the policy, and we've got to have some discovery, Your Honor, in order to find out what Mr. Farrelly was talking about when he just summarily wrote a letter and said there is no land coverage for landscaping when that's what the deck page calls for. Furthermore, each of these plaintiffs received a certificate stating from the broker stating that there is coverage for landscaping, and that's how they came to make Ms.
Now, that
Brown.
came from Wolfpack Insurance Services, the broker?
It did, Your Honor, a former co-defendant before this case was bifurcated. Yes.
Judge, if I may point out, in answer to your question, the plaintiffs allege in paragraph 20 of their First Amendment complaint that their contract with ACT was dated May 23rd, 2016. Point out one or two other things that I think Mr. Buttermore is relying on. He said to you that an accident is unknown, and frankly, that's nowhere in the First Amendment complaint that there's a question about whether there was an accident or not. All he pleads in the First Amendment complaint, and he attaches his lawsuit against ACT as an exhibit, is that these were intentional acts by ACT. So there's no dispute here over whether there's an accident or not. And similarly, the statement that I just want to correct about Atlanta Casualty having fought discovery in 4 courts, the very first time Mr. Buttermore propounded discovery was last month after the case had been transferred. So discovery is not an issue here. This is a case of contract construction, and I think you hit the nail on the head when you said that it's a breach of contract action, and that in and of itself disqualifies coverage.
Well, they paid money and they expected to have appropriate services and workmanship provided, and they didn't get it.
Correct.
And I don't see, everything they did was intentional. They put they removed the railroad ties, and they had dirt out there, and they apparently didn't do a good job. Mr. Buttermore, it sounds like you want to depose the person who wrote you the letter. Is that correct?
Yes, sir.
And Judge, that would be irrelevant because whatever the letter states doesn't make a difference if the policy itself excludes the coverage. So
I've read the file. I've read the pleadings. I think, Mr. Ginsburg, you have the better argument. But what I want to know is, will you pay them any money to settle the case and get it to go away?
Judge, obviously, I haven't asked my client that question, but I think as a matter of law, we're entitled to a judgment. So I think the answer is no. And it's unfortunate what happened to these folks, but this was not something that is covered by the insurance policy. And frankly, there were things that they could have done to protect themselves better at the time they got the certificates of insurance. But in any event,
So you're saying, what effect does the fact that the policy expired on August 12th, 16 have to do with the case? If work started in May of 16, is that just a red herring? Doesn't matter?
Well, I mean, it doesn't matter in the sense that there's no coverage anyways, but what it has to do with is the fact that they're claiming that the coverage events. The occurrence was when ACT abandoned the work in December, which was after the policy was canceled. But yes, it doesn't really matter because under any circumstance, even if the policy covered landscaping or lawn care instead of demolition and railroad ties, it still wouldn't matter because this is a breach of contract and it's excluded. So no matter what the policy classification is irrelevant too.
Judge, if I could respond to that, this is
Yes,
King
sir.
Buttermore. Mr. Ginsburg says again that the breach occurred after August 12, when apparently, we don't even know for sure, but apparently Mr. Horn didn't pay his monthly premium to a third-party collection company. And the collection company, by the way, had paid Atlantic, we've learned, for the entire year's coverage. But somehow this third-party company terminated the policy because he missed one payment of $300 and some. And so trying to make the breach after August 12 is a stretch. The breach occurred when, just because he kept working after his insurance expired does not give the insurance company an out for damage to the property that occurred before the policy expired. We have all kinds of questions about why, when the policy expired and what caused that to happen. We took the deposition of Mr. Wolf at Wolfpack, and he had a hard time explaining. He couldn't even remember the name of the third party he'd placed the policy with, and he didn't have a copy of the policy. It's been a tough row to hoe. So I appreciate very much your suggestion about trying to get this resolved, because I want to let the court know that we were successful this week in serving and having a fourth defendant added. There is a managing general agent between Wolfpack and Atlantic. It's called McClellan and Hine. And Wolfpack placed the policy with McClellan and Hine, and they selected Atlantic. Apparently, it's very fuzzy, but apparently Wolfpack didn't pick this surplus lines carrier. McClellan did. So now we have the following defendants: Mr. Wolf individually, Wolfpack Insurance Services out in Woodstock, Atlantic in North Carolina that wrote the policy, and now we have the managing general agent. So this is a great opportunity for a mediation to try to get a resolution, and these parties could all come together and work this out, and the plaintiffs could be made whole potentially. So we would encourage you to follow that idea and see if we can't get a mediation going.
Have the other parties answered yet? Mr. Buttermore?
Wolfpack and Wolf, discovery is completed in there. They do have a motion for summary judgment. By the way, Your Honor, Wolfpack and Mr. Wolf filed a motion for judgment on the pleadings that was argued on February 18 of 2019, and it was denied by Judge Poole out in Cobb. So now they've filed a motion for summary judgment. And so that's where we are with those. McClellan hasn't answered. As part of the agreement to let them, for them to come into the case, we gave them till August 1 to answer. And so I would say it's premature for Atlantic to be dropped out of this case, to leave it to the broker and the broker's owner, Mr. Wolf, and the managing general
What are the
agent
theories?
to fight this out. We need
What are the
everybody in the
theories?
case.
What are the theories that you're seeking to recover from the other parties for?
Negligent procurement, Your Honor, because of these mix-ups. We have certificates that say landscaping services. We have that were issued by Mr. Wolf and signed by him, the owner of Wolfpack Insurance. And we have the declarations page that says landscaping operations is the main business of the company. Atlanta Cross Ties is in the retaining wall business. And Judge, let me just read this one sentence. It's Exhibit I in the complaint. I don't want you to have to go there. It's just the denial of coverage letter from Mr. Forelli dated January 25, 27 to Ms. Brown, one of the plaintiffs. He says in the third paragraph, our investigation revealed Atlanta Cross Ties Inc. is not classified not classified for landscaping operations under the insurance policy they have with, he uses the term ACIC, it's Atlantic. How can he say that, Your Honor? That is a tremendously inconsistent, in fact, it's the opposite of what the deck page says, and it's the opposite of what 3 separate signed certificates. I know they're not contracts. I'm not trying to make that point, but it's evidence. And so these plaintiffs relied on the fact that Atlanta Cross Ties got their insurer to send them proof that they had this policy for the kind of work that was being done here. There's even a dispute about whether or not it should have been landscaping, because all the paperwork that was in the case, all the paperwork from Atlanta Cross Ties Inc. talks about their retaining wall business. That was their main business. And we don't know what happened, but we think the wrong policy was issued because they needed coverage for the retaining walls. It appears to me that's the kind of work they were doing. Whether or not they also cut some grass along the way is not the question. So we just don't understand why Atlantic should be able to walk away from this case after its agent wrote this letter that's untrue. It is not classified for landscaping operations. Well, what about the deck page and the certificates, Your Honor? That would be the question we would ask.
Mr. Ginsburg.
Because even if it was classified correctly, which it wasn't, it still wouldn't be a covered event under the policy. There was no accident. There was a breach of contract. It's excluded. We've got no dog in the fight between Mr. Buttermore's clients and the insurance agent and I guess the
That case pending in Cobb County?
That's in Cobb County. We were bifurcated and sent to go our separate way. And so we're entitled to go our separate way, take our judgment on the pleadings and let him have at it with them. But we don't have a dog in that fight. And the case law in Georgia is really clear that the insurance agent is not our agent and doesn't bind us on a policy.
Let me ask you this, Mr. Ginsburg. I think you're right, but I want to know if you'll pay some money to get them to leave you alone. I'm not talking about a lot of money. I'm talking about $10,000. I think you're right. I think you're entitled to a judgment on the pleadings, but I'm sure they're going to appeal, and judgment on the pleadings is certainly less favored than summary judgment. But I think you're right, and I want to know if you'll pay any money. I'm not in the business of making anybody do anything, but I want to know if you'll pay some money to get them to let y'all go away and not appeal it.
Judge, all I can say to you at this point, since I don't have any authority, and as a matter of fact, we've got a claim against counsel and the plaintiffs for fees. I don't want to go there, but if he files an appeal, I'll be glad to go to my client and suggest that that's what Your Honor was recommending.
Well, I'm not in the business of making anybody do anything. I think you are entitled I've read the entire briefs. I think you're entitled to it. So what I want to do is, I want y'all to, how can we do this, Ms. Romero? Let him call his client and Mr. Buttermore call his client and come back to this. How do we do that?
Judge, what we may just need to do is to end this meeting and then just set a time this afternoon for everybody to come back to a Zoom meeting. That may be the best way to handle it.
Let's do this. Let's have a Zoom. What is our calendar like tomorrow?
Let me see, Judge. Hold on one second. You do have an 11:30 today, Judge. And so what we could do is ask counsel to come back after that time.
Let's put it on for tomorrow. Will you reach out to your clients, counsel?
Yes, Your Honor.
Mr. Ginsburg?
Judge, I'll do that. May I suggest?
I'm not trying to make you do anything. I'm telling you, I think you're right. And I think that if y'all really truly want to go away, talk to them. So let's come back tomorrow. Can we do tomorrow at 11, Rupal?
Judge, I just heard from Miss Wood. She says that you have a very full criminal calendar tomorrow. Is there any way we can resume this conversation this afternoon?
Can we come back Monday?
Judge, can I make a suggestion?
Yes.
How about, since we're done with the argument, that I simply email your staff attorney and Mr. Buttermore if I have an answer one way or the other, and then if the court feels a need to have another
I don't think we need to do that. I think that what I want to know is, I'm inclined to grant your motion, Mr. Ginsburg. What I want to know is if y'all will pay $10,000 for them to split to go away. So email Ms. Romero, and if we can't work that out, Mr. Ginsburg, submit an order. Good to be with y'all, and I thank y'all for your courtesies and professionalism. Thank you.
Thank you, Judge.
Thank you, Judge. Miss Sanders, do you need anybody? I'm sorry, I can't hear you.
I need Mr.
Can-
Buttermore.
I need to speak with Candace
Okay, let's see if I can do
after
this.
everybody's gone.
Miss Sanders, is there any way that you can call his office? I'm not sure
Sure.
I
called him
can.
before this year.
I'm
I'll
not sure
contact
I'm very good
afterwards.
with the
Oh,
room.
no, you're perfectly fine. I
Okay,
appreciate
thank you
everyone.
all.
Call that number you called a moment ago. I would answer the phone immediately.
All right,
Thank
you guys
you.
have a lovely day.